Attorney Joe Knight, thank you so much. You represent Ryan Vassar, who is one of the four former top officials in the Texas Attorney General's office who filed a whistleblower lawsuit against the Attorney General's office. And I know you and your other colleagues recently wrote an op-ed for the Dallas Morning News and perhaps other newspapers across the state about the importance of the legislature approving this settlement agreement. So talk to me about the importance of this.
Well, it's important because it's the way the statute is written, and it's the only way that justice is achieved in this case. I think it's there's sort of a popular misunderstanding out there that the lawsuit is against the Attorney General, Ken Paxton, and that's just not so. The lawsuit is against the Office of Attorney General, which is the state agency that employed my client and the others, and the state agency that fired them wrongfully. And the way the legislature wrote the statute, the only entity we could sue was not Mr. Paxton, but instead the Office of the Attorney General.
And I know during a hearing this morning before the House Appropriations Subcommittee, the chief of litigation for the Attorney General's office explained that to lawmakers. And yet some were still wondering if, because the AG is obviously the leader of the organization, and he was running it, and these are his decisions, essentially. And so that's why I think there's a lot of people out there saying, well, wait a minute, he may be trying to have it both ways. Your thoughts on that?
Well, I do understand why some people may see it that way, but on the other hand, there's nothing unusual about that. All state agencies, the Office of the Attorney General to any other agency you might want to name, including the legislature itself, operates only through their human agents. And so there's, in any employment case against the state agency, there's going to be a human being who is responsible for making the decisions that are at issue in the litigation. That doesn't change the fact that it is still the agency that is the employer, it is the agency that is the defendant in the case, that the state is obligated by statute to defend the agency when a lawsuit is brought against it. And when that lawsuit is resolved with a settlement or a judgment, I think it's the state's obligation to pay that. And the alternative here, as I suppose in any other case where a settlement might not be funded, is that the litigation continues, which means there is a continuing draw on the state fisc to finance the litigation from the agency's perspective. And as Mr. Hilton made the point this morning, that's likely, if the case is to resume instead of resolve, it's likely to cost the state taxpayers quite a bit more money in the long run than it would be to fund the settlement and get it over with now.
And that's because of two reasons, right? The cost of defending the lawsuit, and B, the potential payout if the state were to lose.
That's right. And I think Mr. Hilton, they're in a better position than I am to estimate their costs. But, when you consider, he said this morning that the state has already incurred close to $600,000 to defend this agency. And we haven't even begun discovery yet. We've been tied up for 2 years on the Attorney General's office preliminary motion to dismiss and the appeals that resulted from that. And so I think it's easy to try to prognosticate from the amount spent so far that if we were to get into discovery and start litigating in a more traditional sense, the cost of defense would be right up there with the amounts we're seeking in the settlement. And then the liability that the state might have, especially if we litigate for a long period of time, could easily be multiples of the amount of the settlement.
Why did the four men want to settle this case now?
Well, I'm not going to, probably get into that very deeply, especially while the settlement sort of hangs in balance, waiting on this legislative approval. But, suffice to say that there is often a point in any litigation where it just makes sense for both sides to trade the litigation uncertainty and expense and inconvenience for the opposite of that, the certainty and the lack of expense and the convenience of resolving it.
And my last question to you, and I appreciate your time, is we've focused a lot of our conversation, and certainly the hearing did as well today, about the monetary cost of the settlement of $3.3 million. But there is non-monetary provisions in this agreement in which the Attorney General would formally apologize to your client and the three other men and remove a press release from the agency's website in which the agency called them rogue employees. Why are those provisions so important?
Well, everybody, you have to realize that we were negotiating as a group, and these men lost really high stakes and prestigious careers as a result of having the courage that they had to go to federal law enforcement officials over what they believed to be unlawful conduct. And they didn't deserve to pay for that act of bravery and that act of loyalty to the state with some of the things that they experienced both in their personal and professional lives and in the press.
All right, Joe Knight, attorney for Ryan Vassar. Thank you so much. We really appreciate it.
You're welcome.